What do you mean they're
'Cause
going to leave out
every
certain things?
action calls for a reaction. So
Okay, well, what was the action?
that Mr. Allen decided to snatch me up, and that's what caused him to get burnt with a black and mild on the side of his face.
What do you mean snatch you up?
Exactly what I mean. As in, he snatched me up. He got physical with me in the car,
Okay.
and that's what caused him to get burnt with the black and mild on the side of his face. Because I told him a few minutes prior to that, I said, "If you get physical with me, I'm gonna burn you with my black and mild." And he got physical with me, so he got burnt with the black and mild. As you can see, he's shaking his head yes, because that's exactly what happened.
Okay, what happened for the other incident?
I'm not too sure on that other incident. It was
Welcome back to Family Court Drama. In today's episode, we're diving into a child support hearing. The state is asking the court to eliminate the father's child support obligation as the child now lives with him full-time. Both parents agree to this arrangement, but the father is pushing for a non-disclosure agreement to be added to the order, citing prior incidents of family violence. He claims the mother burned his face with a black and mild during an argument and has threatened him in the past. The mother denies the allegations, arguing she was defending herself after the father became physical with her. Let's see how the judge decides in this case.
True. Miss Heifer,
yes, ma'am.
Mr. Allen.
Yes, ma'am.
All right, you may both lower your hands. And Mr. Talley, you may proceed.
Thank you, Judge. We're hearing a suit for modification of support order and to confirm support of rearage. We have an agreed order, if I could state those terms.
You may.
The order contains a child support judgment against Mr. Allen after a possession credit is applied in the amount of $0 as of April 23rd, 2024. Mr. Allen will be ordered to apply for or maintain the child on private health and private dental insurance available to him through his employer. There's a finding that the child subject to this suit currently resides with Mr. Allen, and so his child support should be modified to $0 per month beginning May 1st. The court cost would be as billed to Mr. Allen, and there is no request for a finding of non-disclosure. That's the extent of the order, if I may call the parties.
You may.
I'll call the mother. Ma'am, would you please state your full name?
Jaden Hypert.
And did you hear the terms of the order that were stated to the court?
Yes, sir.
You understand those terms?
Yes, sir.
And are you in agreement with those terms and believe they are in the best interest of your child?
Yes, sir.
Has there been any family violence between you and Mr. Allen in the last 2 years?
No, sir.
Do you have any other child support cases where family violence is a concern?
No, sir.
Pass the witness, Judge.
You may call your next witness.
And I'll call the father. Sir, would you please state your full name?
Armand Allen.
And did you hear the terms of the order stated to the court?
Yes.
Do you understand those terms?
Yes.
And are you in agreement with the terms and believe they're in the best interest of your child?
Yes.
Are you requesting that the court make a finding of non-disclosure as it relates to your address?
Yes.
Has there been family violence between you and Ms. Hypert in the last 2 years?
Yes.
Okay, can you tell the court when when the instances occurred and what the violence was?
It was November 18th, 2022 and August 27th, 2023.
Okay, and what was the violence that occurred on those dates?
There was an argument on November 18th. There was an argument in the car, and I got hit. That it didn't go pretty much further than that. And August 27th, it was at a gas station, and I got burned on the side of my face
By what?
by a black and mild.
Okay. Were the police called for either instance?
No.
Do you have any safety concerns regarding Ms. Hypert having your address because of these instances?
Yes, and I mean, there's been some threats. I'm not really worried about it, but I just want, like, if I were to move to not, the address not to be in the order. That's the only thing.
Pass the witness, Judge, and just ask for a ruling on the issue of the non-disclosure.
So these were the only two occasions, Mr. Allen?
That I can actually have a date on. Yes.
Okay. And why were, I guess you haven't told me enough. I don't know. Can you explain the situation why you got punched in the face?
Um, I mean, it was just an argument. I mean, it was between me and her. I mean, I don't know the context of it. I mean, the argument that was in 2022. I mean, but I know we were in a relationship, we were arguing, and it ended with violence, and yeah,
So you're not in a relationship anymore, correct?
no,
And since the ending of the relationship, has there been any violence?
no,
Okay. And so is there any reason for there to be any violence at this point?
but it shouldn't be, not
So
at all.
how old is the dependent in this cause?
She is 4.
He's 4?
She.
She is 4?
Mhm.
Okay. I have a hard time ordering a non-disclosure on a 4-year-old because mom needs to know where her child is. If it was you and she wanted a non-disclosure based on those facts, I'd have a hard time because you would need to know where your child is. So how is she going to visit with this child if you don't?
I have no problem like letting her still go over to see her, or spend time either like every a week, or like we just had a pass off about like a month ago, where she stayed over there for about a week. I mean, so I have no problem with allowing a child to go see her mother, but it's just for my safety and just for in the future, and just so there ain't no vindictive, there is no type of vengefulness and because of the act or whatever. I would just like my address to be, off the order.
Okay, well, let me ask Ms. Heifer some questions. Ma'am, what do you have to say about this family violence?
I have nothing to say about that, to be honest, because they gonna tell what they want to tell, and they gonna leave out certain things. So that's why I'm just over here laughing right about now.
What do you mean they're
Because
going to leave out
every
certain
action
things?
calls for a reaction. So
Okay, well, what was the action?
that Mr. Allen decided to snatch me up, and that's what caused him to get burnt with a black and mild on the side of his face.
What do you mean snatch you up?
Exactly what I mean. As in, he snatched me up. He got physical with me in the car.
Okay.
And that's what caused him to get burnt with the black and mild on the side of his face. Because I told him a few minutes prior to that, I said, if you get physical with me, I'm going to burn you with my black and mild. And he got physical with me. So he got burnt with the black and mild. As you can see, he's shaking his head yes, because that's exactly what happened.
Okay, what happened for the other incident?
I'm not too sure on that other incident. It was probably an argument and then it turned physical, but I'm not too sure strictly on that. So I'm not going to speak too much on it.
Okay, well, I'm not going to find a pattern and I'm not going to grant the non-disclosure. What I'm going to say is that everyone should conduct themselves as an adult and everyone should keep their hands off of the other person. And other than that, I will accept the agreement of the parties, make this agreement the order of the court, and I will tell you that if you do not like my ruling, you may you have 3 days to appeal and 30 days to file a motion for new trial.
Yes, ma'am.
Okay. Any questions?
No, ma'am.
You have a question, Mr. Allen?
Yes. Well, about so you're saying there that you won't grant the non-disclosure. So
No,
what
sir.
about the threats about, so does my safety not matter in this situation? So
You
I'm just
didn't
supposed to
say
be
anything about any threats, sir. You gave me 2 instances
I
of
mean,
why you wanted a non-disclosure. I asked you if there was anything else. You said no. You said those
I
2
already
things made you
provided.
feel unsafe. And I don't think that is a pattern of family violence, or that reaches the level that needs to be a non-disclosure. As I said, You may appeal. You have 3 days to do that and 30 days to file a motion for new trial.
So the evidence I've already provided, it doesn't matter.
It didn't rise to a non-disclosure for me. It might rise to a non-disclosure for the district judge. I said for me, it didn't. I didn't say it didn't matter. I said it didn't rise to the level where I thought I should give you a non-disclosure. I didn't say it didn't matter.
So did you see it? I just want to know if you see
Did I
seen
saw what?
the text messages.
How would I see them? Did you show them to me?
I provided them to the child support office.
I'm not the child support office. I'm a separate entity, sir. So I haven't seen any of that.
I'm thinking that y'all are all
No, sir, we're
they are
not.
all joined. So there's been like violence. There's been threats against me and against my family. I mean, I have them to think about. So, as I don't want to be no sitting duck, and for her to just be able to at any time she wants come shoot up my house as she's threatened to do. I mean, I have a child here now. I have a mother
Mr.
here.
Allen,
I'm just
you have 3 days to appeal, 30 days to file a motion for new trial. Maybe when you go to the district court, you'll be able to show them all the evidence, and then maybe they will have a better vantage point and can give you your non-disclosure. Based on what I saw and what I heard, I don't have that, sir. And that's all I can tell you. I know you didn't know that the AG's office and the court were separate entities. I don't see everything that you sent to the AG's office. Unless you show it to me, I don't see it.
I mean, I have it.
Unless we do it in a hearing, I don't see it. I mean, you can give it to me now, but I've made my ruling now. So now you have to
That's dangerous.
now you have to appeal it, sir.
She said, okay.
Okay.
And whoever that is over there giving you counsel and putting the thumbs down up on that's not acceptable. Okay? I made the ruling based on what I heard. Thank you. You have 3 days to appeal and 30 days to file a motion for new trial, sir. See that right there. Who keeps putting the thumbs down on there?
Thumbs down.
Somebody is controlling your computer. So that's fine. No problem. Do either one of you have any other questions?
No, ma'am.
You have any questions, Mr. Allen? Mr. Allen, I'm not saying that what you're saying is not true. What I'm saying is it was not presented to me in a proper form. So I could not make that decision. That's why I'm telling you, you can appeal it. And maybe by then you'll have all your evidence and you can show it to the district judge and they might change their mind. Okay?
Okay.
All right. Thank you, sir. You're both free to go.
Thank you. Have a good day.
What a wild case. The judge approved the agreements between both parties on child support and health insurance, but ultimately denied the request for a non-disclosure agreement. The judge ruled that the father did not provide enough evidence to support the need for one. What are your thoughts on this decision? Should the father have been granted the non-disclosure agreement, or did the judge make the right call? Let us know in the comments below. Thanks for tuning in, and don't forget to like and subscribe for more family court drama.